SEC tried to extend deadlines after being fooled by Ripple. With the deadline for discovery moving closer, the U.S. Securities and Exchange Commission (SEC) versus Ripple Labs claim intensified for the current week with a progression of filings on June 2nd from the two sides in regards to discovery and deadline extensions. Slowing down might be the SEC's technique to hurt Ripple's business to a state of arriving at their ideal settlement conditions. Something else, fair notice defense could fix the regulator for quite a long time. The U.S. SEC requested that Judge Annalisa Torres broaden the deadline times for both reality and master discovery by 60 days. The protections regulator contended that the expansion would be far-fetched and postponed any preliminary since two of the three defendants have moved to dismiss motions. Hello everyone, welcome to Future Crypto. Here you'll be informed about the daily crypto news along with the price predictions and updates. In today's video, we'll talk about the SEC trying to extend the deadlines, Ripple hitting back at the SEC's request, existential threat to Ripple's business, and other issues in discovery. SEC and Ripple seeking extensions to deadlines. As anticipated by Ripple, the SEC is now asking a court to extend the deadlines for discovery by 60 days, with fact and expert discovery to end on August 31st and October 15th, respectively, according to a separate legal filing. Requests for deadline extensions are common in discovery. In a June 2nd letter to U.S. District Judge Annalisa Torres of the Southern District of New York, the SEC's senior trial counsel, Robert Moy, explained that apart from the disputes over discovery, there were still pending documents from Ripple, and the agency needed more time to complete depositions as well as review and produce documents to Ripple. In another letter to U.S. Magistrate Judge Sarah Netburn, filed on the same day, Ripple's lawyers are also asking, with the support of the SEC, for extensions of two deadlines related to the sealing and redactions of documents in a hope to avoid burdening the court with unnecessary disputes. Ripple's executives seeking discovery from 16 foreign exchanges. Ripple CEO Brad Garlinghouse and leader executive Chris Larsen are requesting the court to issue letters of request for international assistance in accordance with the Hague Convention to authorities in the Cayman Islands, Hong Kong, South Korea, the UK, Singapore, Seychelles, and Malta to acquire archives identified with their records and XRP exchanges on 16 foreign cryptocurrency trades, to counter the SEC's charges that their own deals of XRP established unlawful speculation agreements, and they had supported and abetted Ripple's supposed protections law infringement. The foreign cryptocurrency trades are Bitmart in the Cayman Islands, Bitfinex, Bitforex, and Huobi in Hong Kong, Bythumb, CoinOne, and Corbit in South Korea, Bitlish and Bitstamp in the UK, BMXDM, once in the past Bitmax, BitTrue, Coinbase, Upbit, and ZB Network Technology in Singapore, HitBTC in the Seychelles, and OakX in Malta, as per the court documentation. The rundown of 9 archive demands incorporates the stage's functionalities and the IP locations of any wallets utilized for XRP exchanging, hot and cold stockpiling. The foreign trades have been approached to react by July 2nd. The lawyers addressing Garlinghouse and Larsen are contending that the SEC's inability to assert homegrown offers and deals ought to be lethal to its cases, for the reasons set out in the individual defendants' particular motions to dismiss. In April, the two Ripple chiefs submitted motions to have the SEC's claim against them excused for all time. The disclosure that the individual defendants look for will be pertinent to exhibiting that the offers and deals that the SEC difficulties didn't happen in this country and are not dependent upon the law that the SEC has summoned for this situation, composed the guard lawyers, adding that the data looked for was to help litigants in countering the SEC's cases against them. Last December, the SEC documented a claim against Ripple, charging that its offer of XRP was an unregistered security offering worth over US $1.38 billion. The SEC likewise named Garlinghouse and Larsen as co-litigants for supposedly helping and abetting Ripple's infringement. The prosecution is in its disclosure stage with the SEC, and the litigants trying to support their case while combating over the data to be shared to the opposite side. Ripple hits back at SEC's request for additional discovery. In a different letter recorded on June 2nd, Ripple hit back at the SEC for looking for additional information, including 6 affidavits and records from 5 custodians, just as reports on its XRP exchanges post-dating the claim and campaigning endeavors. Although introduced as a basic discovery dispute, the genuine import of the SEC's motion is uncovered in the primary reference, extension of the current July 2nd close-of-fact discovery deadline, composed Ripple's defense lawyers in a letter to U.S. Justice Judge Sarah Netburn. The court allowed the gathering of 10 testimonies each. At that point, the SEC concurred that it was imperative to determine this case quickly. Presently, only weeks from the end of discovery, the SEC has shifted its perspective. The SEC's most recent solicitations for one extra disclosure are ridiculous and ought not be utilized as a premise to broaden discovery, affirmed Ripple's protection lawyers, noticing that the SEC had gotten 67,000 records from Ripple, summoned 47 outsiders, and had 10 affidavits on top of its 2.5-year examination, where it got 50,000 archives from Ripple and summoned 5 Ripple witnesses. SEC's request poses an existential threat to Ripple's business. On June 3rd, the regulatory agency formally requested the government judge for a 60-day extension from disclosure for Ripple's situation. The SEC claims it needs more opportunity to depose witnesses on the case. Thus, it's mentioning an additional 2 months to finish that. Ripple's legal advisors have recorded a note of issue with the adjudicator, saying that this is certifiably not an adequate motivation to change the disclosure plan. Plus, if the court allows this augmentation, this would be biased to Ripple since the SEC misquotes the justification for this deferral. The SEC's letter misquotes the explanations behind Ripple's resistance to broadening disclosure. Ripple goes against this expansion since postponement will be incredibly biased to Ripple and on the grounds that there isn't an acceptable aim to adjust the disclosure plan. In general, Ripple's letter to the court expresses that should the postponement be conceded to the administrative guard dog, it would introduce an existential danger to Ripple's business in the U.S. The witnesses the SEC wants to depose. Among the additional witnesses the SEC wants to depose are the former CFO of Ripple, Ron Will, and former Senior Vice President at Xspring, Ethan Beard. In late May, back then, there were 10 witnesses present, and formal Ripple staffers were ready to testify on various matters related to the Ripple case. The reason for the delay and more witnesses to depose cited by the SEC is that during discovery, more evidence arose, including that of the sheer scale of Ripple's unlawful XRP offering. Other issues in discovery. At the core of the claim is whether exchanges including XRP comprise investment contracts. At the core of the claim is whether exchanges including XRP comprise investment contracts and securities, subject to enlistment under Section 5 of the Securities Act of 1933. The result of the SEC's lawsuit against Ripple and assurance of XRP's status is in effect firmly looking for its conceivably broad ramifications for the cryptocurrency industry. Judge Netburn managed to deny the SEC admittance to Ripple's confidential material and privileged legal advice. In her decision, she presumed that Ripple had not put its emotional perspective or exhortation of guidance at issue and didn't postpone its lawyer-customer advantage by affirming that the SEC had neglected to give fair notice to the market with regards to whether XRP was viewed as a security. Ripple's reasonable fair notice defense is a vital mainstay of its defense. So guys, that's it for today's video. I hope it could be a big help to you. Let us know in the comments. Don't forget to click the bell icon, and thank you for watching.